I want to thank you all for attending today's webinar on professional liability insurance specifically for law enforcement officers. Before we get started, just like to give you a little bit of information about myself. I also am a former federal employee. I was an attorney for a federal law enforcement agency for several years, and then I worked many years defending federal employees, and a lot of that was federal law enforcement employees at my old law firm, Shaw, Bransford, and Roth, where I was a partner, and I did some similar legal work for a similar professional liability insurance company before founding Feds. Now, these seminars typically take an hour and a half, but we realize that many of you don't have that kind of time, or more importantly, patience. So we created this abbreviated version. So I have a lot of information to get through in 15 minutes. So I'm going to ask you to please hold your questions until the end. And then I promise, I will stay on as long as necessary to get all your questions answered. So just getting started, it has been my experience both, working in a federal law enforcement agency and defending federal officers for over 17 years that they have the most exposure. And in fact, the whole concept for liability insurance really was created initially for law enforcement. And it was actually the vulnerability that law enforcement officers, that vulnerability was the driving force behind the congressional mandate for agencies to pay up to 1/2 of the liability insurance. And in my opinion, these reasons that you, federal law enforcement officers, have this increased vulnerability compared to other federal employees is because what I call these three toys right here, the gun, the badge, and the car. Very often your personal and financial liability exposures are somehow related to these three, what I call toys. And it is only fitting that the main liability exposures come in threes as well. So the three areas of exposure that we will cover today are civil lawsuits, civil personal liability, administrative, this is professional, this is your job liability, and criminal exposure. We're going to start out with civil exposure because this is, again, one of the main reasons that Congress passed the legislation to pay for half of the insurance for you, and it's probably the reason many of you are interested in obtaining coverage. These civil suits, as a law enforcement officer, you've heard them called Bivens actions, constitutional torts, personal capacity lawsuits, individual capacity lawsuits. Whatever they're called, what you need to appreciate is that you don't have absolute immunity for these kind of lawsuits like you do for lawsuits under the Federal Tort Claims Act. So there are three main points we want to emphasize here for civil lawsuits, and those are representation, the immunity, and indemnification. Representation first. If you get sued, the first thing you want to consider is who's going to defend you. DOJ representation, believe it or not, is not mandatory. It's not automatic. It is the sole discretion of DOJ to decide whether you will be assigned a DOJ attorney to defend you. Even if it's clear that you are acting within the scope of your employment, DOJ must also determine that it is in the interest of the United States to provide you with defense counsel. And what does that mean, interest of the United States? It basically means whatever DOJ wants it to mean. In practice, this means that the denial most often happens if you are being investigated for some sort of wrongdoing or misconduct for the very same reason that you're being sued. You can see that DOJ is not going to be on both sides of that. The next concept is immunity, and I've already alluded to this. You don't have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. You only have something that's called qualified immunity, which is still pretty darn good. The final concept we want to introduce to you is indemnification. Indemnification is important to understand because even if DOJ they determine it is in the interest of the United States to represent you, what you have to understand, it's still a lawsuit against you. It's still a personal capacity lawsuit against you. So if DOJ reps you and they lose, you can still be held liable. You can still be liable for the judgment. And that's where the part of the Fed's liability policy comes into play, is we would provide the indemnity protection for that in the form of either $1 or $2 million. The other place where the Fed's liability policy really comes into play is if DOJ denies you representation. And as long as you're within the scope of your employment, we will assign you an attorney to actually represent you and defend. So while you still may be able to get the case bounced under the qualified immunity, what we call QI, you would have to pay anywhere from $20,000 to $50,000 to hire your own attorney to do that. If DOJ declined representation, the Fed's policy would provide you a lawyer for that. So if there is a judgment entered against you, I do want to emphasize that you, or at least tell you that you can request indemnification also from your agency. The requirements for indemnification are just like the representation, scope, interest of the United States, and finally the agency must have regulations governing the indemnification process. The scary thing about indemnification is before you can even ask your agency as to whether they will indemnify you, you actually have to have a judgment entered against you. So these civil lawsuits are usually, and you guys have seen them, alleged violations of First Amendment rights. Most of them are Fourth Amendment, but we also see Fifth and Eighth Amendment, which is cruel and unusual punishment. So just to recap here on civil, what I want you to take away from this discussion is an understanding that you can be sued personally, DOJ can deny representation, and you can be held liable for a judgment. And the liability insurance protects you in these three major ways. It provides a legal defense if DOJ will not defend. It pays damages if you are held liable and your agency will not indemnify. And this final thing I hadn't talked about yet is what we call coverage counsel. If DOJ is on the fence as to whether they will represent you or not, we will hire coverage counsel to go in there and try to convince DOJ that it is in the interest of the United States for them to represent you. Because at the end of the day, we're all better off if the United States government is representing you. Also, we may appoint coverage counsel in particularly egregious cases to kind of oversee, not really supervise, but kind of be involved and oversee DOJ's representation of you, because at the end of the day, the liability exposure is both of ours. So in particularly egregious cases where you have dead bodies and things like that, we'll appoint coverage counsel. Final thing with civil, I would like to say is, this is my full disclosure, is civil suits without DOJ representation are rare, okay? I want to be, fully disclose that. And liability is even rarer, okay? But when it does happen, it's usually law enforcement officers that are the ones that are exposed. And for $135 a year, which is what the insurance costs after you get reimbursed, why would you take the risk? Why would you risk that? The next area we want to talk about is administrative. The Fed's liability policy pays for legal defense up to $200,000 for any disciplinary or judicial sanction proceeding or administrative investigation into alleged misconduct for any act or omission committed by a federal employee while rendering a professional service. So this is any administrative investigation, whether it is an OIG, OPR, OSC, congressional, EEO, any internal management investigation that could result in a personnel action against you. The Fed's policy provides you an attorney to defend throughout the investigation, and in the unfortunate event there's a disciplinary action imposed against you, proposed against you, the policy will provide an attorney to defend both at the agency level and, if it's necessary, to appeal it to the Merit Systems Protection Board. It provides coverage there as well. What you need to appreciate here, and this is one of the barriers we see to people buying liability insurance, is they almost feel like they have to envision themselves doing something wrong to actually need it. And that's just not the case anymore. So whether your action is intentional or unintentional, you really just need to remain cognizant of the fact that you will be held accountable for even the most trivial or justifiable misuse or abuse of authority, violations of agency policies. Allegations can come anywhere. They can come from a subject, a target, criminal defendant, member of the public, special interests, politically motivated elected officials, like what's going on in ATF and Project Gunrunner right now, a federal judge, or even somebody from your own agency. And if you had a Fed's professional liability policy and you were the subject of one of these administrative investigations, the Fed's policy would defend against it would help you defend. A lawyer would help you prepare for the agency administrative investigation process, attend the investigative interview with you if the lawyer is permitted. It's discretionary on the part of the agency as to whether they let lawyers in on the investigation, and actually defend you in any resulting disciplinary actions. It's always good to have a lawyer involved at the earliest stages of any professional misconduct allegation to advise you. So that's administrative, and the final exposure area we want to talk about is criminal. Whenever I talk about the criminal provisions of the policy, my agents always say, hey, we're not criminals. We put the bad guys away. And while that is true, you also need to appreciate that there is very little that you can do wrong in the federal government and not have it also be a violation of Title 18, which is the criminal code. Some of the most common criminal allegations involving federal law enforcement officers usually involve allegations of assault, abuse of authority, shootings, providing false or inaccurate information in investigative documents or court testimony. One of the biggest examples I like to give, most people remember the Martha Stewart trial. There was a Secret Service agent that testified against Ms. Stewart in DOJ's case in chief. DOJ felt he lied, felt he committed perjury, and they turned around and prosecuted him for perjury. He had a professional liability policy, was able to get adequate legal representation through it, and eventually got acquitted. If you are notified that you are the subject of a criminal investigation, it's absolutely important for you to talk to or retain a criminal defense attorney before you talk to anyone. And as a federal employee, what you need to appreciate is you can't just sit around and wait for an indictment. If you sit around and wait for indictment, it's game over. The important part of our policy and covering you for criminal investigations at its earliest stages is we get a lawyer involved to really work the AUSAs, whoever's prosecuting the case, to actively work them to get you what's called the declination of prosecution. This is just a quick overview, again, of what the liability insurance covers. Lawsuits, we talked about that, $1 million and $2 million of indemnity protection, also provides legal defense there if DOJ declines to rep. We defend you in administrative and disciplinary matters, and we defend you in criminal proceedings. This is a very important concept to understand, that Congress has authorized agencies to pay mandated up to 1/2 of the cost of this insurance. This official support really demonstrates Congress's understanding that there are risks associated with your federal employment that they cannot completely cure with legislation. So it is Congress's belief that PLI is necessary for certain groups, such as law enforcement officers, to have peace of mind they need to help them make the tough decisions that are part of the job. That's why they want to share the cost with you. They want you to be protected, so they've authorized appropriated dollars to help share the cost of this insurance. And I should mention here the cost of the insurance. The Fed's main policy is $270. The $2 million policy is $370, and with the agency reimbursing one half, your base policy only costs $135 a year. And if you just think about what you spend $135 on each year, hopefully you can see that you're getting a lot of protection for that. These are just some final examples I want to throw out there of some civil lawsuits and administrative matters and criminal investigations that have happened, over the course of the last 15, 20 years. These are actual cases involving federal employees. You all should recognize some of them. One I want to mention, I alluded to earlier, that's going on in the news media today, involving the Bureau of Alcohol, Tobacco, and Firearms, Project Gun Runner. I'm sure everybody in law enforcement has heard about that. Everyone from the street case agent to the assistant director who authorized the operation is vulnerable in that case, has had to go up and testify in Congress, has had to go testify before the IG, is possibly vulnerable to some administrative action. If you had the Fed's policy, you're one of these agents, you would have a lawyer by your side throughout the entire process. The final slide here, I can't emphasize this point enough. You need to have the insurance in place before something happens, okay? You can't buy the insurance after your house is on fire. I can't tell you how many people call us after an incident. It takes less than 5 minutes to get enrolled. And we also have payroll deduction available, which is just $12 a pay period or $16 a pay period for the $2 million policy. The easiest way to get enrolled is right there online. You go to our website. As I said, it takes less than 5 minutes. If you don't like to do things on a website, you can call us. You can download a form. You send in a check that way, or you can do it the old-fashioned way. You can call us on the phone. And one of the things we pride ourselves here at Feds is if you call us, somebody's going to answer the phone, and virtually anybody who answers the phone can help you. So that concludes my presentation, right within 15 minutes, I think. So I guess we'll open it up for questions, and we're gonna facilitate the questions through Kathy, who's administering the call.
Okay, Tony, we have a question currently. It's, does the plan provide coverage of an attorney support at the letter of counseling, letter of reprimand discipline steps?
Yeah, it's a good question. And the answer is yes. If you receive any formal discipline, you're going to get a lawyer to defend. So if you got a letter of reprimand, even though the agency just can issue the letter and not propose it, you can be assigned an attorney to grieve it. You have a grievance right within your agency grievance procedures, so the Fed's policy would provide an attorney. Now, you mentioned the letter of caution. It would not cover it for the letter of caution because under OPM's rules, that's not formal discipline. But what you do get with the Fed's policy is we give you these 2 free half-hour legal consultations for things that aren't covered. So the letter of caution, if you wanted to file a grievance on it or want to get some advice on what to do about it, you can be assigned an attorney to answer your questions, to review your grievance, and give you that free consultation. And then for any other disciplinary action, a suspension, 1 day all the way up through to an adverse action, that's obviously covered, what I call cradle to grave, from the proposal period up into the conclusion.
Okay, Tony, the same gentleman has another question. Will an attorney personally appear with us at an appeal hearing?
Absolutely, absolutely. Interpret, you mentioned to be an appeal hearing is if you get a proposed disciplinary action as a federal employee, you get due process. You get a right to review the evidence and to respond in writing and orally. The attorney will review the evidence with you. The attorney will write the written reply for you and submit it, and the attorney will go in with you and make your oral defense. It usually always will involve some personal statement from you, but you have a legal right to have an attorney present, and we absolutely authorize for them to go in. We pay for them to travel, if necessary, but, that's an important part of the process.
Next question is, what makes this PLI better than writing companies?
There's a lot of what I call objective differences in our policies and writing companies, and I would encourage you to get on our website where we got a base comparison, but I'll run through them real quick. We're a little bit less expensive. We don't cap legal representation for civil matters. That's important. Their defense for civil matters, the legal defense when you're hiring a lawyer is capped at their $200,000 limit, which they provide for their administrative defense. Ours, you get the full $1 million and full $2 million to provide the legal defense, where theirs is capped at the $200,000 limit. Our claims handling, we have an independent third-party claims handler that makes coverage decisions. They make their decisions in-house. We don't. We separate that process to avoid any appearance or conflicts of interest. A big difference is something called the clawback provision they have tied to your criminal coverage, and this basically means that they have a right to recover legal fees against you in criminal matters if they defend you and you're adjudged guilty. We don't have a similar clawback provision in our policy. We don't charge some of these administrative fees. They've got a $26 administrative fee on their insurance, and you're legally not supposed to get reimbursed for that piece of it. We give free consults, and if you look at their various policies, there are 5 or 6 types of policies that they have with additional endorsements. Our base policy includes all those. So for marketing purposes, they're putting out different information that say this is covered at this rate, this is covered at that rate. All of that basically is in our base policy, and we don't charge extra for that. But the bottom line is our commitment and know-how. I'm a former federal employee. I'm not an insurance guy. we're trying to run a program that really does right by federal employees. It's our superior legal defense. Our main legal panel, Shaw, Bransford, and Roth, has over 25 years have been the leaders in federal personnel law. They're the absolutely best out there, and when I could talk about work a little expensive here, we give pro rata refunds, but at the end of the day, when the stuff hits the fan, you want to know that you got the best legal team on your side, and that's what the Fed's policy provides. And I would just suggest also, if you look on our website, and see the endorsements that we get from leading federal employee associations, I would just suggest that there's a reason why they're endorsing us over all other insurance policies.
Okay, Tony, another question is there an opportunity for my agency to not contribute the congressional mandate of 50%?
No. If you are an eligible employee, meaning if you are a law enforcement officer as defined by the statute, it's a mandatory reimbursement. The law does say up to 1/2, so agencies could technically set that lower than the 1/2. Historically, they have not. They've capped it. If they've capped it at all, they've capped it at $150. So even in desperate times, budget times, and continuing resolutions, and all those shenanigans that happened last year, the reimbursement still was mandatory. We even had some federal agencies try to discontinue it, not knowing that they couldn't, until the lawyers came in and informed them that the federal law requires a reimbursement. It's a shall, not a may.
Thank you, Tony. I have a question from Cedra, and she also has her hand up. If you are a subject of an investigation, who do you contact first if you have liability insurance and you are a member of FLIOA?
That's a very good question. There is some overlap in the benefits that we provide and what FLIOA provides. It is the administrative piece of it. So FLIOA's legal benefits would provide you legal representation throughout the agency administrative process, investigation, internal disciplinary action. If you have to appeal it outside of the agency, that's when the Fed's benefits would kick in. So often people will utilize, to preserve their insurance money, their insurance funds, they will utilize FLIOA services first and then kick it over to insurance. And we work very closely with FLIOA with Larry Berger and FLIOA when that happens. It's important, I think, to have both. The other two parts of the policy for Fed's PLI is a civil provision, a criminal provision. That's not provided with your FLIOA membership. So it's important. It's really important to have both. The other thing I'll say on behalf of FLIOA, since I work so closely with those guys, is you get a tremendous amount of advocacy support from them here on Capitol Hill, and they get stuff done for you as federal law enforcement officers. So, that alone is an important reason why you should be a FLIOA member, in addition to fully protecting yourself, having Fed's professional liability insurance. I should mention, and that's another difference between us and some of the other providers. If you're a FLIOA member and you went with FLIOA first, and then when you had to appeal it to the MSPB or at some later time you wanted to switch to your insurance benefits, they will deny you coverage for failing to timely notify. We will not. We work with FLIOA that way. We want to be a partner, and and this is also a little thing I like to say is we're a part of your community. We're involved with your associations. We're a part of your community in providing you this important benefit.
Thank you, Tony. We have a two-part question here. Who do we go into our agency to get the agency's portion of the payment? And is it sent directly to Feds from our agency?
No. Good question. The way it works is you pay in full with us, and we give you a certificate of insurance and a reimbursement certificate. You take that and you turn it into, along with, it's usually an 1164, excuse me, 1164 form. You turn that in, and the agency reimburses you. It operates pretty much like a travel voucher reimbursement. So whatever form you would turn in if you took a taxi somewhere to get reimbursed, that's what you would turn in with your certificate of insurance and reimbursement certificate from us, and the reimbursement gets processed automatically. Every agency has an internal policy on exactly how it works, and it's different at every agency. Some agencies say you can get reimbursed right away. Some say you have to wait a year. Some say it has to be at the end of the fiscal year. It's different. But if you search your agency's intranet for professional liability insurance reimbursement, you should be able to get a hold of your agency's policy. And if you let Kathy know or call us later and give us your email, tell us what agency, we can probably email you your agency's policies, because we have most of them. But the emphasis is you do pay up front, and then you go get the reimbursement.
And I'm sorry, Tony, did you answer the second part where does it get directly sent to us?
No. I thought I answered that. You're paying in full, so the reimbursement goes directly back to you. It goes back in your direct deposit, back in your checking account, like a travel voucher reimbursement. So it's not coming to us because you're paying in full. You've already paid. You take your reimbursement certificate, and the agency pays you for half of it.
Thank you. Next question. Does the Fed's plan provide education, training, risk management services to members like other PLI providers?
We provide you a subscription to Fed Manager and Fed Agent, which is basically some free newsletters that provide information out there. We often partner with a nonprofit called OmniGov Training to provide free training, to the federal government on issues that we think you would be interested in, such as retirement benefits, financial issues, workplace violence type issues. So yes, we periodically, have these free seminars available to our members.
Okay, it looks like this might be our last question. Do you provide coverage when assignment is overseas?
If I understand the question correctly, it's after you've exhausted your limits with the policy, you're going to be responsible for the additional legal fees. I could tell you, practically speaking, in a lot of these cases, if you've usually exhausted your liability insurance fees, you can often work out. Yes?
May I interrupt you? That's, do you provide coverage when assignment is overseas?
Overseas, okay, worldwide coverage, yes. Yes, absolutely. That's part of the example I was trying to make. When we talked about, Fed's base policy has everything that one of these other policies try to add on, charge you extra for what's called worldwide coverage. That's covered in our base. So you're covered anywhere in the world while you're performing your federal position.
Thank you very much, Tony. It looks like that's all our questions.
Okay, I thank everybody. I hope you found it useful, and if you don't have liability insurance, I hope you get it, and I hope you get it with us. Thank you.